And thank you for joining us for Litigation Basics episode number 4, Anatomy of a Trial. My name is Stephen Reingold, and I am your moderator. This webinar is part of the Financial Poise webinar series, Litigation Basics. Slide 6 of the slide deck summarizes this episode, and slide 7 provides a summary of the series. Speaking of the slides, however, we will not step through the slide deck in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the slide deck handy, though, because I will try to indicate what slides our conversation is touching on as we proceed, so you can take notes. Our panelists today are Andrea Cox of Lux Santaniello, Jeffrey Leon of Caron, Tim Pastor of Montgomery McCracken Walker and Rhodes, and Jeffrey Tentoff of Goldberg, Miller, and Rubin. And again, my name is Stephen Reingold, and I'm from Saul Ewing. Now, we appreciate that you're not spending your time and money to attend this webinar to hear infomercials about us. You can read more about us on slides 34 through 38. This webinar is a production of Financial Poise. To sign up for our great free weekly newsletter, go to www.financialpoise.com or send an email to info@financialpoise.com with the word subscribe in the subject line. This webinar is being sponsored by the National Law Review. We thank you for your sponsorship. If you are attending the live premiere of this webinar, you could submit questions using your web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include your question in the name of the webinar episode, and we will do our best to get you an answer. Okay, with that introduction, let's get started. So today's topic, anatomy of a trial. We're going to jump right in, trial start to finish, a higher level overview. Andy, I'd like to start with you. And one of the key things we talk about in trial prep is a trial theme. Can you tell our audience what is a trial theme?
Sure. Good afternoon. The primary purpose of a trial theme is to emphasize the importance of certain evidence and to persuade the jury that you've got the stronger case. And to do that, you want to use repetition throughout the trial because people tend to remember what they hear more than once. It's important to start thinking about the theme as soon as a new case comes in, because you're going to want to apply that theme during the discovery phase, when you're sending out interrogatories, when you're taking depositions of witnesses. You want to know what your best story is, and you want to think about the essence of your case, and that will help you form your questions during the discovery phase. That way, by the time you get to trial, you should have some good sound bites from the discovery and the depositions to work your theme into the opening, into your witness examinations, and closing argument. You also want to make sure that your client knows the theme and is prepared to weave it into their testimony. Don't make the theme too complicated. Jurors will come from all sorts of different backgrounds. They'll be in different age groups and education levels. You want everyone deliberating to know what your theme is.
Thank you, Andy. So other decisions you make early on include, what evidence you're going to present at trial. Tim, let's throw this over to you. How do you choose what evidence you want to present at trial?
Well, to first answer that question, Stephen, I think it's important for our viewers and listeners to understand that in the course of a litigation, there will be a lot of documents produced, depending upon the scope of the case, of course, and complexity. But that doesn't mean that all the documents that get produced and shared between the parties ultimately end up at a trial. Instead, there's a winnowing process where over the course of the case, as you start to understand the issues and the issues narrow, and perhaps there's intervening rulings by the court, you'll start to settle on the documents that you would introduce at trial. And you should be selective as trial counsel. And one of the ways to do this is to determine what are the claims and defenses in the case, what are the elements of each of those claims or defenses, and do you have documents that goes to each of those elements? Sometimes you might only have testimony and not a document. Other times you only will have a document. If you have a document that goes to a claim, an element of a claim or a defense, then the likelihood is that that's going to be an exhibit at trial, unless those facts are already stipulated, as sometimes happens. So this is the process whereby we go through a broad set of documents, narrow them to a set that will likely be trial exhibits.
Great, thank you. Jeff, let's throw this over to you. So, a lot of us have had experience with jury trials. A lot of us have had experience with bench trials. Does it affect your presentation if you're trying to the court as opposed to trying to a jury?
For sure it does. For one thing, you're going to expect that the judge is going to have a greater understanding of your case for several reasons. One, it's likely your judge has been presiding over the case since it was filed. In some states, that's not the case, because in some states, you get assigned a trial judge, like literally on the day of trial. But most of the time, your judge has a familiarity with your case. So when I say dumbing down, I'm not trying to insult a jury, but especially with complex issues, you have to simplify things for a jury that you may not have to do for a judge. There are also things that the judge can just review offline, whereas you have to actually present things in real time to the jury while they're sitting in the jury box. There's a lot of differences, and it does change your presentation. In fact, you may not even have opening arguments, with a bench trial.
Okay, thank you. So Jeffrey, let's move over to you. One of the early stages of trial, of course, is pretrial procedures, pretrial efforts. What are some of the pretrial procedures that one would expect to have to undertake before the trial actually starts?
So again, and I think this caveat goes for everything everybody said, it's all going to be jurisdiction specific, and within even the jurisdiction, it could be county specific or judge specific within each county or each district. So really, it starts with the pretrial order is what you have to look at. And that may be with or without a pretrial conference. If it's at a pretrial conference, there will likely be a pretrial conference scheduling order that will lay out when certain things are due, including a pretrial statement, identifying witnesses and exhibits, as well as deadlines for motions in limine, which are evidentiary motions to bring up at trial. There will also be deadlines for turning over jury charges, verdict sheets, things like that. And again, this could be either just in an order or in an order following a conference. And if it is at a conference, you can bring stuff up to the judge then and make sure that you're clear and understand everything. One of the most important pretrial conference issues is probably your trial conflict letter. If you have a vacation or another trial scheduled, please make sure you notify the court of that pursuant to the pretrial order. That's probably going to be one of the most important things. If your client has a vacation or a doctor's visit or something like that coming up, please make sure that they're aware of those conflicts. And most jurisdictions will honor those conflicts as long as you provide them timely. Again, this will all be laid out by the order, so you start with the order, and you primarily go from there. Again, they may have their own specific procedures that the judge has. And you may get those procedures, as Jeff was saying, if this judge has been with you throughout the trial of the case, you may have gotten the judge's trial procedures on day one when it was first assigned to him, and you may have to refer back to that. The other one thing I wanted to mention is the pretrial statement is almost always required to identify witnesses and exhibits, and you may be precluded from calling certain witnesses or presenting certain exhibits if they are not included in that pretrial statement. So be over-inclusive in the pretrial statement rather than under-inclusive. Same thing with jury charges. It's a lot easier to pull one out and agree to not have a jury charge presented than it is to try to add it in later. So always in the pre-trials, I recommend being over-inclusive. File more motions in limine because you'll be able to argue them later than if you don't.
Jeffrey makes a very good point, is know your jurisdiction. Some federal districts, there will be local rules on what a pretrial order must contain. Some judges have standing orders as to what a pretrial order must contain. And you may get that pretrial order early on in the case. You know what it's going to look like. I know, Andy, for example, Florida, some of the judges in South Florida, some of the counties, they're issuing these case management orders in the early days of the case that lay out right up front what your pretrial, when your pretrial order is due and what it has to say. So 6, 9, 12 months in advance what you need to be shooting toward. Okay, let's go back, Andy, since I tagged you there. Let's stay with you. So it's time to prepare your witnesses for trial. What are some best practices?
My first thing is to make sure that my witnesses know my theme, because you want them to be able to weave it into their testimony, not in a really scripted kind of way, but you at least want them thinking about the theme as they're thinking about their answer. So of course, on direct examination, I can't lead the witness. I have to ask it pretty much an open-ended question and expect them to say it in the way that I want them to. So I prepare a direct examination outline, and I provide a copy of that outline to the witness days in advance of the actual trial. I go through it. We talk about what their testimony is. I figure out, if there are questions on my outline that they don't understand or isn't triggering the response that I want, and then I can finagle the outline. But I want them to know exactly what I'm going to ask. I don't want them to have any surprises at the trial. Sometimes that's not doable, like with experts, they don't have the time. But certainly with my own client, I'm going to do that 10 times out of 10. You want to show them the evidence that you intend to introduce through their testimony, so there aren't any hiccups about getting the judge to admit that into evidence. If you've picked up on your opponent's theme, you can work with your witnesses on ways to discredit their theme and to reinforce your own. Sometimes it's just a soundbite, but going back to what I said earlier, the theme is why jurors remember your case. So you want to go through it with your witnesses. I encourage also a mock cross-examination where they don't know what they're going to be asked and you want to see how your witness is going to react. Picking the order of your witnesses is also important. If they've been deposed, you should have a good idea of who is a likable witness, who comes off as credible, and who doesn't, because unfortunately, you don't always control who your client is, and some are better at others presenting in front of a jury. So you want to pick who you think is going to be most credible and likable. And to the extent you have someone that either isn't a strong witness or isn't likable, I try to hide them somewhere in the middle. But you want to begin strong and end strong. Who goes first doesn't also have to be the person who has the chronological story, but they should be able to provide enough testimony on what your case is about so that the jury is following along.
Great, thank you for that.
Can I add something real quick, Steve?
Yes, of course.
So I do a lot of defense work, and often my client will be called first, out of order, as if on cross. And so I just want to note, you should be, if you do defense work, you should be prepared for that, and you should have your witness prepared as a defendant day one, even though your case in chief may not start for several days later. So I just wanted to bring that out.
No, it's an excellent point. Thank you for sharing that. Okay, so we've started talking about witnesses. Let's talk about exhibits, use of exhibits, introducing exhibits. We could probably spend a whole hour on this, but Tim, let me throw it back to you. What are some tips for introducing exhibits into evidence and using them during trial?
Well, earlier I mentioned that in the course of the case, there'll be a lot of documents exchanged by the parties. And the reason I'm reemphasizing that is by the time you get to trial, the parties should be very familiar with the potential exhibits. And the reason that is relevant is because that makes it more likely they'll stipulate to the admissibility of the documents. And so you want to do as much in advance with your adversary to determine which exhibits will be admitted by stipulation, meaning an agreement of the parties. Courts like it when parties agree to such things. It makes for a more expeditious trial. In the absence of that, and that could happen with a few documents, depending upon the nature of the case, the nature of your adversary, it could be that there are a few documents where there's no agreement reached as to the admissibility of the documents. And that doesn't mean all hope is lost, just means a little more work for the party that wants to introduce that evidence, that they'll have to lay a foundation for the evidence. They'll have to make a motion, a verbal motion to the court for the admission of that evidence. And the court will then have to make a decision, typically on the spot. Sometimes courts will reserve those types of decisions, but typically they'll either admit or deny the admission of that particular exhibit. But again, in most sophisticated cases with sophisticated counsel, you can reach these types of agreements in advance so that both parties going to the trial understand what exhibits have been pre-admitted. And again, it makes it a much smoother process for the court, for the witnesses, if it's a jury trial, for the jury, which is of particular interest for the judge, because the judge doesn't want the jury to have to sit through a bunch of foundational testimony by witnesses bearing upon the admissibility of exhibits. Instead, the jury and the judge, on behalf of the jury, is eager to have those documents pre-admitted.
So staying on the issue of evidence that's going to be seen by the fact finder, the jury, in our example here, one of the things that Jeffrey talked about, and Jeff, this is a question for you. One of the things Jeffrey talked about was motions in limine as part of your pretrial procedure. So if you know you need to object to some evidence coming in, or you seek other evidentiary rulings from before the trial begins, can you walk us through a little bit more about what is a motion in limine and when would you want to file one?
So a motion in limine is a motion you make beforehand, anticipating testimony, that may be elicited or subject matters that may come up that you don't want to come up. Actually, an motion in limine actually can also, you can seek a filing in advance on the admissibility of certain approaches and themes you want to bring in, because it's easier to get that established up front than it is piece by piece, question by question or document by document at trial. So you're seeking a broad sort of peremptory ruling. It's often for things that are prejudicial, for example, a prior criminal conviction, a drug, a prior history of drug addiction, stuff like that, or, stuff like that, and it depends on the nature of the case. It's stuff you don't want the jury to hear. So Jeffrey talked about the pretrial procedures, and most courts have a process for when they want motions in limine to be filed. Now, that isn't necessarily preclusive, and you can wake up one morning on the third day of trial and decide something may come up, and you want to file a motion in limine that morning to prevent something. But in general, you have to follow the court's procedures. So you file a written motion. It should be supported by some case law. It should identify what you want to preclude with some specificity. The other side can file a written answer, and usually you have arguments before the trial starts, but not always. And one important thing to know about motions in limine is that once granted, they aren't like chiseled in stone like the Ten Commandments. You can revisit them at trial, and in some ways, in order to preserve an appellate point, you have to make a proffer of relevance as to what question you would have asked. Obviously outside the ears of the jury, and if you believe that in some ways the door has been opened by a witness, you can't just ask the question. You have to ask the judge, approach the bench and say, Your Honor, the witness just opened the door to this. Please revisit your ruling and allow me to do that. So, that's just some of the basics of motions in limine. We could do a whole 1 hour seminar on motions in limine themselves and, the rules of evidence, which are tightly bound into, the general subject matter of any motion in limine.
Yeah, and one of the things that we often find illustrative in these webinars for our audience is war stories. They really give a flavor to what we're talking about. So just 30 seconds, if you'll indulge me. So my second summer in law school, I was a summer associate at a large law firm, and my first research assignment was having to do with a motion in limine to preclude evidence at trial. And it was a product liability case, a machine piece of equipment used in an aluminum manufacturing plant, and an employee had gotten his hand caught in the machine. And our job was to keep out of the eyes of the jury the photographs from the emergency room and from the surgery. And so, I got to research and draft a motion in limine, trying to keep those photographs away from the jury because they were more prejudicial than probative. So those are the kinds of things, you need to be thinking about. Is a motion in limine necessary before the trial even begins? Or, as Jeff said, if it's come up at trial, you weren't expecting it, get that on file.
Even
Yes.
along those lines, I had a products case where the plaintiff attorney continually referred to my product as napalm. So I had to get a motion in limine filed on that.
Yeah, I hope it was granted. Yeah. So, okay. That is prejudicial. My gosh. Okay. So, Jeffrey, let's come back to you. We file lots of pleadings before trial actually begins. What about a trial brief? What is a trial brief, and when would you want to file one?
So typically, and there may be a difference between a jury trial and a bench trial. If there's a bench trial, often it will involve a much more complicated matter than a simple negligence claim or something like that. And in those situations, you may want to file a trial brief, and the judge may specifically ask you for a trial brief on a specific complex legal issue. So in those, they may be in a bench trial. I would expect that you may file a trial brief similar to the way that you would file a motion in limine in a jury trial, but often at the request of the judge themselves. In a jury trial, my experience is that a trial brief is when the judge asks you for a brief during the trial, as opposed to a motion in limine that was filed before trial began. So this may be a supplement to a motion in limine. The judge may ask you for a trial brief that touches upon some issues that were brought in a motion in limine, but that weren't flushed out, or that the judge has a question about that neither party had thought of to address in their motion in limine. It may also, in my experience, it typically comes around the jury, the charging conference. When you start talking about the jury charges and which jury charges are appropriate, the judge will often ask for a trial brief on it. There's also, if you move for a non-suit, that's at the end of the plaintiff's presentation of evidence. If they haven't met a burden, the judge may ask you to brief some of these things. Or at the end of the defendant's case, if the plaintiff moves for a directed verdict or some other dispositive ruling by the judge, they may ask you to brief it then. The one thing that I will say is that trial briefs are typically very time sensitive. They're in the middle of trial, so they're done often during lunchtime. And unless you have a really good associate that you can ask to do it, I like to avoid trial briefs if possible. And one way to do that is by fleshing things out in motions in limine beforehand as well. But
if I can,
yeah, go ahead.
Oh, sorry, Jeff. I was just going to add something. One good practice, I think, for trials and anticipating trial briefs on particular issues is there are certain things may come up, or certain evidentiary questions that may come up that you don't want to just argue off the cuff with the judge. And what you do when you kind of know this is coming is you prepare you know, you can call it a bench memorandum in advance, right? And if it comes up, you can just say, Your Honor, here are my reasons. I actually have a bench memo on this. Here it is. And, you know, that way your argument is more expansive. It's in writing. You're not, you know, looking for cases or trying to do research on the cuff. So, that sort of goes hand in hand with the issue that Jeffrey is raising. I just wanted to point that out.
That was an excellent point. Thank you both. Okay, back to you, Andy. More pretrial drafting. What are jury instructions and how do we use them?
Jury instructions tell the jury what the issues are for them to resolve and what the applicable law is. Many courts have standard jury instructions which cover your typical types of cases, like for instance, negligence, duty, breach, causation, damages, or breach of contract, find that there's a valid contract, performance by a plaintiff, breach by a defendant, and damages. And in many of those same jurisdictions, the standard instructions are presumptively correct. But you might have a case where there's a certain wrinkle or something where you think the law is slightly different because of how your incident occurred. And you can propose a special instruction, which means it's something that you wrote and that you believe is supported by case law applicable to your venue. Some courts also have standard verdict forms for your typical types of cases. And that form is what the jury fills out after they've made their decision on how the case should turn out. The verdict form really acts like a decision tree. So for example, if it's a breach of contract case, the first question probably will be, was there an enforceable contract? And they're told, if your answer is no, go no further, sign the bottom of this form and return it. But if the answer is yes, they go to the next step. And did the plaintiff perform? And then the next step and the next step until they're finished with the decision tree. But again, not every case is standard. So you will have instances where you're going to have a specialized verdict form and ask the court to permit its use.
Okay. So let's stay on the topic of juries. So Tim, back to you. Keeping in mind our audience is largely made up of people who are new to litigation, what do you think they ought to know about jury selection?
Well, Stephen, it may be hard for you to believe, but I also was young once. And when I was young, I was instructed by some very erudite, wise teachers that when you step even remotely close to that courthouse, you presume that everyone you're encountering is a prospective juror. So that's the first piece of advice that I would give. Hold the door open for people, smile. The impression that you make with jurors starts well before you even get in that courtroom because you may encounter them outside. And it's your job as a litigator, whether the senior most or the junior most litigator, to develop a rapport with jurors. Of course, it's important for the senior most to the extent that they're the ones participating and presenting to the juror, but all members of the trial team have to have a favorable rapport with the jurors. The second piece of advice, which I think is part of what Andy was remarking about, is that you can argue your case in the jury selection process. Now, this will depend upon the judge and the forum, but there's an opportunity for you to ask questions of prospective jurors that gets into the facts of your matter, that gets into the trial themes. And so for young litigators who are thinking that this process needs to be rigid to the point of where you cannot ask questions of the juror that are pertinent to jurors that are pertinent to the actual case before them, well, again, could depend upon your judge and jurisdiction, but when you have that opportunity, you should take advantage of it. Now, there may be jurors that answer questions in a way that is not convenient for your claims. And in such cases, if you can make an argument to a judge why they should be removed for cause, perhaps they said something that was prejudicial to your client or your position, and You can make an argument that they should be removed from cause, and if the judge agrees, that juror will be removed from the ultimate jury. You also get something called preemptory challenges, which is where you can strike a juror from the jury pool even without arguing that they should be removed for cause, but it's just because. But what young lawyers don't realize is you can strike a juror for a preemptory challenge for almost any reason except a bad reason. And a bad reason would be, for example, their race or their religion, just as a general matter being a basis for a preemptory challenge. Now, sometimes pulling back the covers, that does happen, but it's not always articulated. And there has to be some basis for your adversary or for the court to think that you've exercised a peremptory challenge based on a bad reason. And if they have some evidence corroborating that, they can raise it to the court. And if the court agrees, then your peremptory challenge may not be honored. So these are very general concepts for jury selection. As you always say, we could spend an hour on it. But hopefully this gives new litigators a very general understanding of the process.
Right. So before we move on in our questions, we acknowledged earlier that everything is jurisdiction specific. On the topic of juries, moving ahead to the end of the trial, I just want to take a quick poll of the four of you. In your various jurisdictions, can you interview the jury after the trial is over? So Tim, let's start with you.
Well, I have the good fortune to appear in a lot of different jurisdictions, but let me just take New York. The answer is yes, you can.
Okay. Andy, how about Florida?
Not typically allowed.
Okay. Jeff, Illinois?
You have to ask the judge.
Okay. And Jeffrey, how about you?
Yeah, it's judge specific, but the vast majority, and I practice in Pennsylvania and New Jersey, the vast majority will allow you to talk to the jury afterwards. But they make it clear that if a juror does not want to talk to you, you're not allowed to talk to them.
Okay. So for our audience, the reason I asked the question is, and this goes to some of Tim's points about jury selection, you learn an awful lot. If you're able to interview a juror or a handful of jurors after the trial, you learn an awful lot about what worked and what didn't, whether you won or lost. And so if you are in a jurisdiction where that is allowed or you get leave of court to do it, take advantage of that opportunity. It is invaluable.
And I would just say, even if you're in a jurisdiction that does compulsory arbitration where more senior attorneys act as arbitrators, reach out to them as well. It's always good to get feedback on how you did, regardless of what the source is.
Yeah, I mean, this is a profession where there is constant on-the-job training. Just because we have gray hair or no hair doesn't mean we're still learning. Okay, so Jeff, let's flip over to you. Now the trial is actually starting in earnest. Just for our audience, what is an opening statement? What should you say or include, and what should you not?
So let's start with the very important nomenclature. It is an opening statement. It's not an opening argument. And that it's important. And some judges are more of a stickler about it than others. What you want to do is you want to tell the jury what they're going to expect to hear and see over the course of however many days. Introduce some of the witnesses that may testify. You can, if the documents are already in evidence, you can foreshadow some of them and show what they are. You almost always have to preface with saying the evidence will show that, because the evidence hasn't been seen yet. And this is a very important thing in an opening statement. You cannot, I mean, you can, right? But it is very bad to overpromise. If there's a risk, you'll underdeliver. If you know what a witness is going to say crystal clear, and you can deliver that, then you can tell the jury it exists. But juries will not only remember what was said in the opening statement, But in closing arguments, a good lawyer on the other side will point out, will take your opening statement and use it against you. Say, remember this? He had this PowerPoint. He said this. That didn't happen, did it? And it can work against you. So there's no need to comprehensively go through all the evidence or all the elements necessarily. It's really thematic. It's setting the stage for what is to come.
Great, thank you. All right, Jeffrey, let's move to you. Openings are done. You're putting on your case in chief through direct examination. What about some pointers for our audience? How best to get through direct examination?
So I think the main key is preparation, right? And preparing your witness that you're direct examining. You want to be there simply guiding them through their story or what their purpose of their testimony is. I think that preparation is key. As Andy had mentioned earlier, go over every question with them. Send them a copy of your outline. Make sure that they know exactly what you're going to be asking them. If you're intending on showing them exhibits, go over every single exhibit you intend to show them and make it so that it's easy for them to find. Put it in order. It's very easy to just print out every exhibit in a simple packet, and then in big black marker, write page numbers on the bottom. So you can say, let me refer you to page 6 if they get lost. I think one of the most jarring experiences at a trial is when you have a witness who's not properly prepped and who is fumbling through their exhibits looking for something. And you're sitting there for a minute or two and the jury's just waiting and you can't ask a question or can't do anything until they get to the point that they want to be at. I often highlight the specific portions of the exhibit I want to show them. So I think preparation is probably the number one key. I think it's also probably the hardest part of our job as attorneys is preparing our clients for direct examination. Never expect that your client actually understands what you're trying to explain to them, or how that never expect that they're going to answer the question you ask them the way that you want them to necessarily. You have to prepare them. The moment they get on stand, it's a different experience for them. Nerves come in, so keeping them calm is very key as well. And letting them know in advance that you're going to be there and help them through it. That if they miss something, you'll ask them to fill it in. That helps calm them down as well. And one other point I wanted to make is a very important part of direct examination is the rehabilitation of the cross-examination, right? I always tell my clients, you don't need to explain any of your answers to opposing counsel. If I feel like I want you to explain it, when he's done asking you questions, I'm going to stand up again and I'll say, do you remember when so-and-so asked you this? Why don't you explain your answer then? And have them prepared with an explanation for that type of situation. Don't leave that to them to just come up with an explanation, not prepared. But that is another key part of direct examination is being ready to rehabilitate any cross-examination that happened.
Excellent point and excellent segue into our next question, Angie. This is for you. What about tips for cross-examination?
If your witness has been deposed, the first thing you need to do is know that transcript as best as you can. I like to prepare a Word document that splits into different topics, and then I will cut and paste from the depo transcript and drop it into whatever topic it belongs, along with a citation of the page number where to find it. That way, if some topic comes up and I'm not expecting it at trial, I can go right to that document, know what we're talking about, and be able to say, well, isn't it true that you said this? Or, do you remember having your deposition taken and you were asked this question and gave this answer? And that's one way that helps me with curveballs. I don't really believe too much in an extensive cross-examination outline because even though you've got depot testimony, it's very fluid at trial. And maybe you didn't ask a certain question in the depot and you're hearing something for the first time. So you have to be able to be quick on your feet, be able to adjust, and think about how you're going to handle this new information. I also think it's important that someone else is taking notes during the direct examination because it's relatively well known if you are writing something down, you aren't actively listening and you can miss something. So have your paralegal take notes on what was said during direct so you can remember for your closing. But when you're about to prepare for the cross-examination, you should be listening to the witness and writing down the pertinent things, the things that you really want to go back on cross-examination, as opposed to just a recital of what that testimony was.
I'm going to throw in another tip for young lawyers and cross-examination. Tim said earlier about, a senior lawyer giving him a tip as a junior lawyer. I had a judge give me a tip as a junior lawyer. Was cross-examining a witness and, was a little overconfident that I was landing a lot of punches and I guess picked up the pace a little, and the judge interrupted me and said, "Mr. Reingold, take a breath." And, I was terribly embarrassed, but I got the point. So, pace yourself. All right, Tim, let's move back to you. One of the things that is overly dramatic in lawyer TV shows and lawyer movies is objections during trial. What's the reality of making objections during the trial?
Yes, so you're right. They can be depicted in movies in ways that give the general public a misunderstanding of how they actually operate. And the reason for that is in movies, you have to tell a story within a limited time frame, whereas trials can go on for much longer, which means that objections aren't always momentary and they're not always immediate, but they are what I think is representative of the fascinating operation of the human mind, because there are times where you as a trial counsel are hearing testimony, and while yes, you should anticipate it, and you may have anticipated it, sometimes it's new to you and your brain has to think very, very quickly about all those rules of evidence that you learned in law school, that you've studied up on in advance of the trial, and now you have to exercise your right to object, but you also have to consider, is this an objection that I should be making? Will it be show the fact finder that I'm worried about this evidence when maybe I'm not worried about this evidence? So all in a split second, you have to make the strategic choice, have a basis for your objection, and determine whether to articulate it. So I do think it is a great example of how the human mind is very, very powerful. Now, sometimes the human mind fails us and we get these things wrong. So a brief war story. I was a third-year law student taking a trial practice class. I went to law school in Boston, and we were at the federal court, the old federal court in Boston, using one of their beautiful courtrooms for our final exam, which was a trial. And so various students were getting various tasks to perform. And someone went ahead and performed a direct examination, and our instructor, our professor, who was the judge, ruled on objections during the course of the direct examination. And then this student sat down and the cross-examination started. And the cross-examination started with a very, very, very innocuous question like, "Can you remind me of your title, Mr. Smith?" And the person who did the cross stood up and very strenuously objected that that had been asked and answered. So that's an example of the human mind not performing particularly well, because that was not an objection that mattered. Yes, that question had been asked and answered. Yes, there was a technical basis for the objection that it had been asked and answered, but no, you should not have objected in that circumstance. And this, our instructor pointed out from the bench, overruling the objection, and hopefully that young student learned a lesson for the day.
Who was the judge?
Well, the professor who was serving as a judge for purposes of this final exam was a litigator in Boston of some renown named Harry Mannion, who was a Boston College Law School graduate, as am I, and our trial practice professor as an adjunct professor for the school. And he did a great job of passing on his skills to the students, including in the course of that final exam.
Yeah, no, I asked because he is very well known in the Boston bar. Okay, Jeff, you walked us through opening statements before. See, I made that mistake. You walked us through opening statements before. Now walk us through closing arguments. Similar question to before. What is a closing argument and what should or should not be included?
So a closing argument is an argument. And what you need to do is you need to tell the jury what you want them to do. You have to take what they have just seen, whether it's a single day trial or, I mean, I've had like a 2.5 month long jury trial. And you have to take the most important things they saw, transcripts, of particularly important witness testimony, key documents, and you have to weave it together into that trial theme that Andy talked about at the very beginning. And you're also going to need to throw the evidence into the elements of the claim that are reflected in the jury instructions. It's very important that the final jury instructions be known to the lawyers before the closing arguments. Because you're going to sometimes want to show the jury instructions and say, okay, this element was it reasonably foreseeable that that would happen? Yes, it was. And here's the 6 pieces of evidence that you saw that establish it was reasonably foreseeable. And, so on and so forth. It's a balance, right? I mean, closings, they can be long, but you run the risk of losing the jury's attention if they go too long. And the shorter the trial in general, the shorter your closing argument can be. But, a closing argument can be 3 hours sometimes. I mean, in some cases, it can be a whole day, depending on the scope and scale and complexity. You have to be careful, right? Because there are certain things you can't say during a closing argument. You can't tell a jury, for example, to put themselves in the shoes of your client. You can't do that. That would draw an objection, maybe even a mistrial. There are certain rules of evidence that govern closing arguments. And if you say something objectionable during a closing argument and the other side objects and it's sustained by the judge, that's a bad look. Like during examining a witness, getting objection sustained isn't that big a deal, right? I mean, it happens. Everybody expects that to happen. But when you get down to the end and you're in your closing and you're saying something improper, at that point, that tells the jury maybe they're, they didn't, actually accomplish during the trial what they're telling me they accomplished, because they have to do or say something that the judge says you can't do that. So, that's the basics of a closing argument.
Great. So let's move back to more of a procedural issue. Jeffrey, this is for you. Sometimes during a trial or at the conclusion of the trial, we make motions that seek to, find in our client's favor, whether it's a judgment as a matter of law or a motion for judgment notwithstanding the verdict. Can you walk us through briefly what those are and why you would file them?
Sure. So motion for judgment as a matter of law is essentially a dispositive motion that's made during trial, typically after the presentation of one party's case. So for example, at the end of the plaintiff's case, a defendant may move for non-suit, essentially asking the judge to find as a matter of law that plaintiff has failed to meet their burden of proof with respect to, it could be negligence, in which case the ruling would be in favor of the defendant at that point. It wouldn't even go to the jury. but it can also be partial, maybe to a specific portion of damages, like punitive damages. If there was punitive damages in the claim and the evidence of punitive damages isn't there. This is not often, this would be made during trial based upon the evidence at trial. So it's not something you would file necessarily. It's something that you would orally make right then and there on the record. At the end of a defendant's case, the plaintiff may move for a directed verdict. At least those are the terms that I'm used to. Non-suit and directed verdict in Pennsylvania. New Jersey may call them something else, and other jurisdictions may call them something else as well. But that's essentially finding that the plaintiff wins as a matter of law on a specific issue. That's almost always going to be partial because the plaintiff wants the issue of the amount of damages, what comes after that dollar sign on the verdict sheet, to go to the jury. So it's typically used for finding the defendant negligent as a matter of law, or finding factual cause as a matter of law. These are summary judgment standard, essentially. So everything, but it's based solely on the evidence at trial. So rather than a motion for summary judgment, which is all of the evidence that's been discovered, this is based solely on the trial evidence and whether, but it's the same standard. All inferences in light most favorable to the non-moving party should be made. Motion for judgment notwithstanding the verdict is a post-verdict motion as a matter of law. This would occur in cases where, like, the verdict shocks a conscience, or if the verdict just seems inherently inconsistent, right? Like there may be an agreed upon amount of wage loss, and then they come up with something that's not the agreed upon amount of wage loss, or outside the range of the agreed upon amount of wage loss. It could also be to mold a verdict based upon a prior agreement, right? You can go into trial with high-low parameters already set. There are also certain jurisdictions that have compulsory arbitration, and if there's an appeal from a compulsory arbitration, there may be a limit based upon certain elections. So in Pennsylvania, you can appeal an arbitration award and then go without live experts, not have live expert testimony, but you read in reports, but it caps it at $50,000. So that motion to mold the verdict, if they get more than 50,000, to mold it to the cap, would be a motion for judgment notwithstanding the verdict. Again, jurisdictions are different on procedure, but you almost always want to voice it at the time of trial, even though you may be able to bring it post-trial motion. You still want to voice it then and there. And even if you think it's a loser, voice it to preserve arguments for appeal. And you never know what might actually stick with a specific judge or an appellate judge. So even if you think it might not be the best argument, voice it, make sure you preserve it for appeal. And then file the post-trial motion, again, preserving it on the same issues.
Okay, Andy, let's kind of stay with a similar theme. So motion practice now, following an adverse determination. Something went wrong, either the jury findings, an evidentiary ruling. How about motions for new trial? Can you walk us through that?
Sure. As the name suggests, you're asking the court for a brand new trial because something bad happened. That could be that you think the judge made an error during trial in terms of excluding certain evidence. Maybe the judge wouldn't let your expert testify because of Daubert. Maybe they wouldn't let an exhibit come in, or it could be the other way, that you filed a motion in limine to preclude certain testimony and the judge let it be heard by the jury anyway. So you point out all these different rulings or procedural error possibly, and you ask the judge to basically vacate the verdict and start trial all over again. Each jurisdiction typically has timelines or deadlines that run from either when the verdict was entered or when the judgment was entered, which can be 2 different days. And they're frequently mandatory. You have to file the motion within that time, or you're not going to be able to seek appellate review of the ruling. There can be exceptions. For example, if you're in federal court and it turns out there was no diversity, you can try to get that verdict vacated or judgment. But typically, you've got to be very careful with those deadlines, or you're going to be in trouble.
Excellent advice. So we've got 5 or so minutes left. I have one more question for you, Tim, and then I want to open it up to everybody for some final thoughts. So Tim, just an overview of presentation style. What are some things that work during your presentation? What are things that haven't worked out so well for you?
I think one of the key components of presenting in a trial setting is to be likable and respectful to all involved, including the court personnel, your co-counsel, of course, the judge, not overreacting in circumstances where in a normal life setting, we might react differently if someone berating us, for example. You just have to roll with it in a trial setting. But above all else, I think you need to keep things simple. One of the values of a good trial lawyer is to simplify things for a fact finder, because all of us on this panel have dealt with very complex cases. And the challenge for us, the reason our clients turn to us, is for us to simplify those in a trial presentation. So I'm a big fan of some visuals. In the old days, we used to put up large pieces of cardboard demonstratives. In more modern times, we use digital tools such as PowerPoint and other presentation strategies that are perhaps more efficient. I have a quick war story, and that is we had many years ago, a trial. We had a visual that was on a cardboard, and it was, we thought, quite compelling. And of course, in our closing statement, we presented it to the jury and discussed it. And we didn't take it down. And then it was for the other side's opportunity to give their closing statement. And they had every right to remove that. But there it sat, right behind my opposing counsel, our great piece of evidence in a giant billboard for the jury to see the whole time that our opposing counsel was presenting their opening statement. So that's a small yet meaningful example of what not to do in a courtroom. If your adversary has some billboard or other trial presentation, it's time for you to take that down when it becomes your turn, because otherwise there's an earnest risk that the jurors are going to be thinking about your adversary's compelling evidence, and that particularly that one piece of evidence, instead of all of the other things that you're saying. So it's important to keep it simple, and it's important to remember your trial themes and not your adversary's trial themes.
Excellent advice. So let's go around the horn in the few minutes we have left. Final thoughts about trials, anything we've covered today. Jeff, let's start with you.
I mean, there's so many things we could say, but I think this is an important one. Just remember, you're being evaluated every minute you're in the sight of the jury. When you're sitting at counsel table, the other side's doing something. They're still checking you out. So you have to be very measured in your body language. You can't overreact to something you hear, because then the jury will see that and they'll think, oh, wow, something bad just happened, right? If you're mad at the judge about something and it shows through your body language, they're going to think something significant happened. If suddenly you get your associates like scrambling in a very disruptive way, they're going to think something significant happened. So you need to have you and your team act very measured. You whisper something, and then they're instructed, if they need to go get something, to do it quietly, deliberately, in a way that doesn't suggest distraction, or urgency or panic. It's just really, really important that you do that. If you're falling asleep at counsel table, that's another thing. And believe me, sometimes in long trials, you want to fall asleep at counsel table.
Jeffrey, how about you? Any final thoughts that you'd like to share?
Yeah, I just want to, one of the things with some of Tim's war stories is learning from mistakes, right? And I think it's important as young attorneys to realize that trial litigation is a practice. It is you are constantly honing your skills. You need to constantly be learning. So get as much experience as you can. Watch as many as you can. If you're able to do arbitrations, do as many arbitrations as you can. If you're able to sit as an arbitrator in your jurisdiction, I highly recommend that so that you can see other people doing their cross-examination and direct examinations at a lower level. But get as much experience as you can. And if you learn from your own mistakes, that's great. But what's really brilliant is being able to learn from somebody else's mistakes. And that's why it's really key to watch other people as much as you can and take what you can from good attorneys and learn what you can from the bad attorneys.
Andy, final thoughts?
Everything we've talked about today sounds like a lot of work, and it is, but it also can be fun and enjoyable. So try to find the enjoyable part of a trial as well.
And Tim, any final thoughts?
The final piece of advice is for young lawyers, attach yourself to a mentor, which is part of Jeffrey's point about learning from others. When you can start your career with someone more senior than you who can foster your development, it can lay a really fantastic foundation for the rest of your career. It's very, very important that young lawyers find someone who can mentor them. And it's very important for more senior lawyers to take that obligation very seriously. And it ultimately can result in the difference between someone having an enjoyable and productive career and someone having a challenging career where they're really not meeting the goals of their clients.
No, as moderator, I reserve the right to make two final comments for the good of the order. So the first one I would remind everyone, and this goes about something Tim said about presentation during trial. There's a lot of technology we use. Know your technology, know how to use it, know how to use it in your courtroom. If you need to get in touch with the clerk and do a practice run with the technology there, you can ask for leave to do that. Don't figure out how to use your trial presentation tools the day of trial. The other final thought that I would share, and this goes to what you've heard about watching and learning. You certainly want to watch trials and learn, take away the good and the bad, but you also want to learn your judge. If you know you have an opportunity to go watch your judge in action, watch your judge conduct a trial, take that opportunity because you want to see how that particular judge handles trials. And if you don't have the opportunity to see that judge handle a trial, but maybe oral argument on summary judgment or something, take that opportunity. You want to know the person you're going to be in front of as much as you can. So with those final comments and my thanks to our panelists, this concludes our webinar. Thank you all for joining another entertaining yet educational production of Financial Poise.